First District Court of Appeal is now in session. All who have business before this court draw near, give attention, you shall be heard. May God save these United States, the great state of Florida, and this honorable court.
Good morning. We have one case scheduled for oral argument this morning, the case of Thomas McGill versus Florida Department of Corrections. We've allocated 20 minutes per side for the oral argument. Mr. Ufferman, would you like to reserve some time for rebuttal?
Yes, Your Honor. 5 minutes, please.
So noted. You may continue, Mr. Ufferman.
Thank you. Good morning. May it please the court. Michael Ufferman on behalf of the petitioner, Thomas McGill. I think there's, in essence, 3 issues in this case. First, how is the offense of first-degree murder committed by a juvenile classified for purposes of game time? Second, has DOC violated its own rule in failing to give Mr. McGill the game time that he's earned over the last 20 plus years? And third, whether or not DOC's actions in this case violate ex post facto principles. Let me begin with the first issue. And a lot of time and effort has been spent by the parties and also the trial court below in trying to determine whether or not this offense is a capital offense. But in preparing for oral argument, I came across something that I think maybe makes some of that argument moot. And that is this. In essence, the department is saying that because of the provision that was in effect in 1994, and this offense occurred in December of 1994, that you look to the guidelines and the way that the legislature assigned offense severity levels to particular offenses for determining game time, that because of this offense of first-degree murder, Mr. McGill is excluded from game time. And a lot of the reason that they make that argument is because there's a provision in 775.082 that says, quote, the 1994 sentencing guidelines that were effective January 1, 94 apply to all felonies except capital felonies. And that's the language that the DOC is relying upon. However, DOC acknowledges in its response that an inmate's game time is generally determined by the statute in effect at the time that he commits the offense. And that provision was not in effect in December of 1994. That provision that DOC is relying upon that accepts out capital felonies did not become effective until October 1st of 1998. The provision that was in effect in December of 1994 said no such thing about accepting out capital felonies. It did define what a capital felony was. And it says in 1, a person who has been convicted of a capital felony shall be punished by death if the proceeding is held to determine whether or not the defendant is eligible for the death penalty, or shall be punished by life imprisonment and shall be ineligible for parole. But we know in light of recent developments from the US Supreme Court that neither of those options is applicable to Mr. McGill. He's not eligible for death under Roper, and he's not eligible for mandatory life with no parole under Miller. But that's the only definition of capital felony that's provided in the statute that was in effect at the time. So DOC argues that, look, for this 20-month period, you had to look to the severity offense level, and first-degree murder committed by a juvenile is not defined under the statutes, and therefore he's ineligible. But that's not completely true.
Counsel, would you concede, though, that if the conviction is classified by statute as a capital felony, it's a capital felony?
Well, no. I think what this is something that courts have struggled with since Miller came out.
Well, but hold on, though. But so, I mean, let's look or talk specifically about 775.081, which I think was in effect in 1994, and 782.04 subsection 1. So 775.081 says that for purposes of sentences and other purposes in statute, a capital felony and a life felony must be designated specifically by statute. And 782.04 subsection 1 specifically says that the crime that your client was convicted of is a capital felony. So how do you get around that?
Your Honor, I can't say any better than what I just said. I'll quote to you again. 775.082 says that the punishment for a capital felony has to either be death or life without parole. So we know neither of those are options. So Judge Osterhaus, in his concurring opinion in the Thomas case, which is cited in the petition, said this, and I quote, "In short, while federal case law has eviscerated Florida's ability to sentence juveniles as capital felons under 775-0821, Mr. Thomas may be sentenced as a life felon under 775-0823A." And that's exactly what many judges and many courts throughout the state have been trying to determine. How do you define first-degree murder committed by a juvenile in light of Miller? And judges have been struggling with this. So at the end of the day, ultimately, the rule of lenity must apply when determining which statute to apply. And there's another provision, and again, I was going back to the framework that was in effect in 1994, 921.0013 does apply to those offenses that are not listed in the sentencing guidelines. And it specifically says a felony offense that's not listed should be ranked as follows, and it gives various options. One of those is number 5, a life felony with an offense level 10. So yes, it doesn't say capital felony, but we also know this can't be a capital felony under 775-082 because he cannot get death and he cannot get a mandatory life. So at some point, when trying to determine what is first-degree murder committed by a juvenile, the rule of lenity would have to kick in, and Mr. McGill would have to get the benefit of saying, okay, the legislature did come up with a system. The system is when an offense is not listed, such as first-degree murder committed by a juvenile, you still have to assign it an offense level, and the offense level that would be most appropriate, obviously in this case, would be number 5, a life felony within offense level 10, because that's exactly what this is ultimately. It is a life felony. He can get up to life, but he can
But
get
it isn't, counsel, it's not a life felony because the legislature said it's not a life felony. The legislature said that under 775.081 that a capital felony must be designated by statute, and the legislature in fact did that in 782.04 subsection 1, that the premeditated or first-degree murder is a capital felony. That's the statute that your client was convicted of. And as far as I know, Miller, nor any other case, rewrote or invalidated those two statutes to say that a legislature cannot designate a particular statute a particular way for classification.
Your Honor, the capital felony the legislature was referring to was the offense of murder where the only two options were death or life imprisonment. That's no longer an option for a juvenile convicted of first-degree murder. So
it's not an option. A court cannot constitutionally sentence a juvenile to life in prison. That doesn't mean that the statute doesn't stand for what it says, which is for classification and maybe for other purposes, that statute is still, or the offense is still a capital felony. But the limitation, the constitutional limitation is on the punishment, not the classification.
So let me approach it this way, Your Honor. Why cannot that capital felony be sentenced pursuant to or be assigned an offense level under 921.0013? There is no, going back to what you seem to be arguing, is that capital felonies are somehow excluded. But again, that language comes from a later version of the statute. That's not anywhere in 775.082 that was effective in 1994. There is no language that said capital felonies are excluded from the sentencing guidelines.
Do you acknowledge that, I mean, I have opened the Florida statutes 1993, which weren't amended with the 94 supplement. So it was in effect in 1994. And 775.081, not 82, 081, says specifically exactly what I just characterized it as saying. And I'm not hearing you tell me where 775.081 was amended by some case or invalidated by some case.
Your Honor, I apologize.
It stands that the legislature must designate a capital felony as such in statute, and that's exactly what the legislature did in 782.04 subsection 1, which was also in effect in 1994.
But to my knowledge, Your Honor, and I don't have it open, but I could certainly turn it and open it. 775.081, it doesn't say the capital felonies are excluded from the guidelines. And that's the argument here, Your Honor. The DOC is saying that we can't score this because the legislature has told us that capital felonies are excluded from the guidelines, but they're getting that language from a subsequent version of the statutes.
However, well, except that if it remains the case that they don't have the authority to grant gain time because it's a capital felony, regardless of whether 082 is in effect at the time, the other statutes also indicate, even if it's not expressed, that capital felonies are excluded because there's not an offense level assigned for a capital felony.
They're silent as to the issue, Your Honor.
Right.
Well, the reason they would be silent as to the issue, and I know this goes without saying, but in 1994, the legislature wasn't thinking that someone convicted of a capital felony would ever have a term of year sentence. The legislature wasn't anticipating either Roper or Miller, but we are now faced with that situation. But the only express language from the legislature that says capital felonies are excluded is language that was passed after my client's offense. And therefore, again, under the rule of lenity, there is a specific statute, 921.0013, that allows for all offenses that are not otherwise scored to be scored. And so the only appropriate conclusion as to where...
Up to and including a life felony, if it's designated as such. And I don't, isn't that continue to be a problem? The fact that the statutorily, the offense that your client was convicted of is classified by statute as a like by label, if nothing else, as a capital felony. And that hasn't changed. Regardless of what the punishment might be authorized, it's not the classifications, the statute doesn't say a capital felony will be defined based on what the punishments are that are allowed. It says a capital felony will be what the legislature says specifically is a capital felony. And the legislature said that the offense that your client committed is a capital felony, and that remains such to this day.
I don't agree with all that analysis, Your Honor. I think courts have struggled with that as well. In the context of cap sex battery, in the context of a juvenile charged with an offense that he would otherwise not be entitled to bail, and we now know under Graham that a defendant cannot get mandatory life. I think courts, there's cases on both sides of that argument that say that it's capital for this purpose and it's not capital for this purpose. If my client wanted a 12-person jury, he would not get it. And that's because of the definition of capital doesn't include the possibility of the punishment of death. So again, I think that falls on both sides. But at the end of the day, I come back to this. There's nothing under the 1994 version of the statute that was in effect in December of 1994 when this offense was committed that excluded capital felonies from the guideline. Nothing that specifically excluded them. They may not have been expressly included, but that's a rule of lenity issue that my client would be entitled to the benefit of the doubt. But the language that the departments rely upon to specifically exclude it was not in effect at this time. Let me quickly jump to my other 2 points that I'd like to make. Number one, beyond this, DOC already had a rule in place that specifically contemplated exactly what would happen in this case. And that's 33-601.101. There was an old version, 33-11.0065, that was in effect in December of 94. And that says death or life sentences cannot be reduced by gain time. However, any inmate serving a death or life sentence will be considered for incentive gain time, and the gain time will be posted so that in the event that the death or life sentence is commuted to a number of years, the accumulated incentive gain time will be applied to the inmate's sentence. That is the exact scenario in this case. The exact scenario. This rule applies to my client. It was in effect in December of 1994. It's still in effect today. My client's previous life sentence has been turned into a term of year sentence of 50 years. Pursuant to the express language of this rule, my client is entitled to that gain time.
Counsel, would you agree though that but for a statute that specifically authorizes DOC to reduce an otherwise statutorily authorized sentence, and that the department needs a specific statute to authorize it to do so? Would you agree with that?
Well, then I would.
I mean, in other words, yeah. DOC cannot on its own decide to reduce a lawfully imposed sentence. Did you agree with that?
I agree with that, but I would also point to the language of 944.275 and sub 2 applies to each prisoner sentenced to a term of years. So by the express provision, my client's current sentence is a term of years. So there is a statute specifically authorizing DOC to apply gain time to my client who is now sentenced to a term of years.
Well, those two provisions don't actually say that. Those two provisions say that the department shall come up with a maximum sentence and a tentative end date.
In establishing this date, the department will reduce the total time to be served by any time lawfully credited. It's correct, and it appears in the gain time statute, Your Honor. So
which lawfully credited for time served. That's not. There's a separate provision that deals with assignment of gain time.
No, I disagree, Your Honor. I submit that when you look at 944.275 in context, this statute sets out a provision whereby the legislature is authorizing the Florida or the Department of Corrections to apply game time to all those who have a sentence of a term of years, with the exception of anyone who might have some type of minimum mandatory that the legislature otherwise said would not apply or would not be eligible for game time. I'm getting close to my rebuttal time. I quickly want to switch to the ex post facto argument, which ultimately I think at the end of the day is the argument that controls in this case. For years, for over 20 years, my client on almost a monthly basis received a sheet from DOC that said, you've been awarded these days of game time. It was not until the Miller resentencing hearing came about that code counsel reached out to DOC to see what his sentence might be, should he be awarded the minimum mandatory under the new sentencing scheme. And at that point that they changed their policy, they came back and they said, oh, this was only for purposes of record keeping. And now the department in its response is using semantics to try to distinguish between something that's been forfeited, something that's been revoked, and something that's been removed. I submit if you look all three in any type of Webster's dictionary, online dictionary, they're synonyms of each other. At the end of the day, DOC acknowledged that they removed my client's game time. How cruel that for 20 years they say, oh, for discipline matters and for record keeping purposes, we're sending you these sheets telling you you've earned all these days of game time so that you'll behave appropriately, only to find out that when he actually gets something that's consistent with their own rule that says if you ever get your life sentence changed to a term of years sentence, you could get access to all of that game time. Oh no, we weren't actually awarding you that game time, although we now acknowledge we've removed that game time. That was only for record keeping purposes, just so we could keep you in line, but you weren't really even getting that game time. That's exactly what the ex post facto principles in both the state and federal constitutions are designed to prevent. My client was expecting he was getting that game time. He was told he was getting that game time for over 20 years. And it's only after Miller came out and it was clear he was going to be resentenced that DOC said for the first time, we're changing our policy. I've cited to the case from the 11th Circuit, the Nutt case. Even a change in the policy for determining how incentive game time is awarded also violates ex post facto. And for that reason, at least up until the point when they changed their policy, my client is entitled to all of that game time that he had already earned. I'll reserve the rest of my time.
Digressing back to your first argument regarding sections 921.0012 and 0013, which set forth the severity level for certain offenses. Do you agree that those provisions do not contain any severity level ranking for a capital or felony?
921.0013 does not mention the word capital felony.
Thank you.
But again, going back to my previous point, the legislature in another statute specifically defined what a capital felony was, and that included someone who could get death or mandatory life. We now know, in courts of struggle, just as Judge Osterhaus said, I mean, it's your colleague on the court. He specifically found that it would be appropriate for a court to classify first-degree murder committed by a juvenile as being a life felony as opposed to a capital felony, because capital sentencing procedures clearly do not apply to a juvenile convicted of first-degree murder. I'll reserve the rest of my time for rebuttal.
Thank you, counsel.
Good morning, Lori Huskisson on behalf of the department. May it please the court. Our position is basically what your honors have already addressed, is that the first degree murder statute at the time designated the petitioner's charge as a capital felony because it was expressly done so in the murder statute. It was clear, it's unambiguous, and it really requires no additional definition. And for classification purposes, when a statute applies it as a capital felony, then that's what the designation is for sentencing. Just because because Miller and Roper happened later and a portion of a statute the sentencing portion may be considered unconstitutional, doesn't mean the rest of the statute's unconstitutional. And the legislature has been clear throughout the course of the years that it is their intent that people convicted of a capital felony of murder, of the worst crime you could possibly commit in our country, are not entitled to game time. That has been abundantly clear throughout the statute that was in place at the time when the petitioner committed his offense, and then subsequent amendments later on. Capital felony, life felony.
Council, with respect to the statute that we're talking about, would you agree that no court has actually invalidated a portion of it? When we're talking about Miller, isn't it true? Miller declared that certain sentences cannot be imposed on juveniles, but it did not address this particular statute, which is a general statute. It's not specific to juveniles.
That's correct, Your Honor. I would agree with that.
So
But just because the sentencing portion changed, it doesn't invalidate the statute is the point I'm trying to make.
yeah, that's what I wanted to check, make sure that you were saying.
Yes, sir. Sorry, I did not articulate myself as well as
No,
should.
that's okay.
Okay, but it's still a capital felony, and for classification purposes in the criminal code, this has a fixed legal meaning, capital felony. If the legislature designated it as a capital offense, it remains that way, even if the sentence ultimately cannot be imposed. And that's been looked at in capital sexual battery, rape, and other types of offenses. There are times when the courts may deviate a little bit when it comes to a procedural rule, such as a 3850, the time periods that a 3850 can be filed, or a procedural rule for how many people can be on the jury based upon the sentence. But as far as the classification and the actual sentence, that does not change. This is a capital felony. It's always been a capital felony. It was a capital felony at the time because the legislature said it was. And just because, and I don't think the petitioner is disputing that he was convicted of a capital felony at the time and throughout, up until he was resentenced, it's always been a capital felony. And the fact that he was resentenced to a term of years doesn't change that fact. And I don't think he's disputing that. And what we're looking at here is whether the lower court departed from the essential requirements of law. And what the petitioner is asking you to do, and he didn't. The lower court said, no, it's a capital felony. He's not entitled to gain time. And that's the decision. What the petitioner is asking you to do is to deviate from that and to carve out a special juvenile exemption because of the fact that his client was resentenced. And that is not appropriate for cert review. And it's not appropriate factually because he's still convicted of first-degree murder. And DOC doesn't have the authority to authorize gain time because he's convicted of first-degree murder, which is a capital felony.
Is that true? Is Mr. McGill not eligible for any gain time? I'm assuming he doesn't get basic gain time because the offense happened after January 1 of 94. But
my interpretation is that he is not entitled to any gain time.
Under B or C, I guess?
Yes, that's the position of our belief, is that he's not entitled to gain time. Counsel did recite to a prior case of Thomas v. State that was in the first DCA. I just wanted to point out that case was later quashed by the Florida Supreme Court. That's not good authority. Also in his brief, the Ortiz case was later quashed as well.
If he's not eligible for any gain time at all, if that's the state's position, why was DOC tracking and accounting for this gain time if it was never going to come to fruition?
Because they're required to. They are required to track for administrative purposes. And I wanted to point out, if you look at, I'm going to look at the petitioner's appendix, which has one of those forms that he was sent. And I'm looking at page 50 just because the scanned copy is not as clear. And that one's a little bit clearer. If you look at these forms, they're titled inmate notice. And they're given out each month as an inmate does something that would be potentially eligible for gain time. The forms, these forms that he's been getting for over 20 years says specifically, the information contained in this notice is provided for information purposes only and is subject to change at any time. It goes on to, when it discusses the portion of the gain time, it says incentive gain time award recommended. And every time he had a recommended award of 20 days for every month that he was doing this one particular program. It doesn't say it was awarded, it just says it's recommended. If you look further down the form, it says the above awards may not apply to any are all commitments based upon sentencing provisions and or disciplinary action, and provides a tentative release date of 99/98/9999 because that's, time he was still under the life sentence. Every month he would get this form saying that these are recommendations. They are for informational purposes only. They may not apply to you. And now they're trying to argue that every month this form that they were given is an award of gain time. He was never awarded gain time. This is tracked for administrative purposes because if he's ever eligible for gain time in the future, they need to have the calculations. They keep track of the records. They keep track of each month where if the court was to order that he get gain time, or if he was to be resentenced under a different statute, he could potentially be eligible for gain time.
Counselor, can you tell me
It's just
which,
administrative tracking.
can you tell me which statute requires DOC to do this for administrative purposes?
It's not a statute. Administrative rules require it, and it's just their policy that they do this. They do this for everybody, regardless of what your sentence is.
It's
across the board.
DOC's own rule.
Yeah, their own rule and their own
Right.
policy that has them track it. They do it for everybody across the board, regardless of what you're sentenced to. You could be sentenced to death, and they will still do this monthly report, and they just keep track of. It's just administrative tracking for potential of gain time for records. And you also
Why do
need
they
to
have to,
remember,
why do they give it to each inmate or each prisoner?
just it's their record, and it's showing if something changes. And you got to remember also, he was also convicted of robbery, which was a second-degree felony, and he could have been, eligible for gain time for that particular, for count 2 as well. But they just give it they do it across the board, and they give it to everybody. It's for informational purposes. It's clear as day on the form. He was never awarded gain time. That's why there's not so the double jeopardy arguments, the due process arguments, the ex post facto arguments do not apply. He was never awarded gain time. This is
What
just tracking.
offense level does DOC use or assign for calculating gain time on a capital felony for informational purposes?
For informational, it appears that they use the 20-day, which would be consistent with the highest level of the level 10 offense. Obviously, if for some reason his sentence was to be overturned and he was to be convicted later of, say, manslaughter, they would use whatever the offense level is for that.
So they'd still have to go back and recalculate it.
They would, but they would have the report of each month of what he did. So he completed this class. A gain time award was recommended if he ends up qualifying for it. And on this one, I'm looking at on page 50 of the petitioner's appendix, was for August of 2000. So they know in August of 2000, he did this class. An award was recommended based upon his work in that class, which, by the way, I would imagine he presented all this at his resentencing hearing too, to show what he's done at DOC. So it's not like there's not some benefit to him having done this incentive class, but they have that. So it's a lot easier to go back and do the recalculation, whatever the offense level ends up being. If he's convicted of a different crime, they will have that for each month of what he did while he was in the facility.
Could the informational gain time, so to speak, be taken away for if a prisoner misbehaves in some way?
Yeah, because it's never actually awarded. So
when I say taken away, like, can it be, they would put it in quotes, forfeited, which is what incentive gain time is supposed to be. You start with 20 days and presumably it can be taken away as well at some other point.
Yeah, if he has a serious enough disciplinary report for some rule that he violated, they could, in essence, take away gain time should he ever be awarded it in the future, and they will issue an order saying, hey, you're going to lose 30 days gain time, and they might have to go into confinement. Sometimes they don't bother when someone has a life sentence to do that, and it just depends on the nature of the offense they committed. So I believe this particular inmate did have a prior circumstance where he lost 90 days of gain time for some type of threat, but he's not that was when he was still imposed on the life sentence. That would just be if there was a situation that arose where he could gain time later, he would lose the 90 days that was ordered.
So from the perspective of a prisoner sentenced to, say, 50 years at DOC versus a person that's serving a life sentence at DOC, this informational gain time versus actual gain time, isn't it for both an accounting measure until their EOS is coming up and like they're looking at it and say, oh, well, by my calculation, I'm due to be released. And at that point, it would be DOC saying, well, yes, you are. Or, no, you're not. So what is I bring this up. So what is the difference from Mr. McGill's perspective? What's the difference, whether it's quote informational or actually accrued, if it's you're keeping track of it one way or the other?
We are keeping track of it, but it hasn't been awarded.
Well, how does that, that's what I'm asking is, what does that look like? Like, how does that feel from a prisoner's perspective when I've now been awarded gain time? Is it a different sheet? Do they get a certificate or something? I mean, what does it feel like?
Oh, what forms? Honestly, I don't know the answer to that because I don't work for DOC. I work for the AG's office, so I don't see their internal
Sure.
forms except for what's involved in the case. So I honestly don't know if they get a separate form when it's awarded. I know they get a tentative release date based upon gain time. And but as far as if there's separate documentation, I really don't know the answer to that.
So Mr. McGill's tentative release date never changed. Is that even with the approval quote of this informational gain time? His tentative release date would remain as whatever the day for day 50 years is?
Correct. When he was still in the life sentence, it just showed the 9999.
Yeah.
But once he was sentenced to the 50 years, then he'll have the tentative release date would be the 50 years.
Right. When for someone that is accruing gain time, it's my understanding under the definition of the statute that the tentative release date could change based on the accrual of gain time. That's the difference
absolutely.
Yeah.
Absolutely. It could change based upon the accrual of gain time if they get disciplinary infractions. Yeah, it's always subject to change. It's not really until they're released. It's really not.
Okay. So in Mr. McGill's,
that much of an interest. It's a conditional interest.
In Mr. McGill's case, other than the change of a life sentence to a 50-year sentence, the tentative release date does not change on this informational sheet. Is that right?
That's my understanding, yes, sir.
Versus someone, and that's the difference. That's how two prisoners similarly situated in some ways. One sentenced to, let's say it's a first degree felony, serving, let's say 30 years in prison, versus someone that's sentenced to a capital felony, is serving 50 years. The prisoner with the 50 years capital felony might receive this informational sheet, but the tentative release date's not going to change. The one doing a first degree felony does 30 years on this information sheet. Well, the tentative release date should change if they're actually accruing gain time. Is that the difference?
I believe so. If they're accruing gain time, then the tentative release date would be lower if they're actually awarded time or just based upon the calculations they have so far. I don't believe it would actually be awarded until their release.
Counsel, let me ask you about the ex post facto argument. Let's assume that you are in fact awarding the gain time each month. I understand your position that you're not. And assume that the statute also does not entitle him to the gain time. So being a circumstance where DOC is now unilaterally awarded gain time that an inmate is not statutorily entitled to. What's your position with regard to whether or not as your opposing counsel has argued that the department would now be required to provide the gain time that he would not have otherwise been statutorily entitled to. Can DOC unilaterally do that and change the statute or violate the statute?
No, the statute controls over if DOC makes a mistake, misinterprets the statute or awards gain time they're not allowed to award. If the statute doesn't, they would effect be in my position a nullity. The statute controls. DOC doesn't have the authority beyond what the legislature designates, and gain times is an act of grace from the legislature. So unless the legislature gives the authority to DOC, anything DOC awards would, if they actually did award it, would have no effect. The statute would control it all the time, at all times.
The DOC's decision to do this informational tracking, which you said was done by rule, was that itself DOC's discretion? Like, did DOC just decide on its own that a better way to run the facility to do it that way?
Well, it is a better way to run the facility because it's just across the board for everybody, and so you don't have an individual employee trying to decide whether these calculations should be done and how to store it for each person based upon their sentence, especially when sentences can be subject to change. So it is better across the board. As far as let me find it here. As far as if DOC is required to do it, or if it's just more of an informal policy, I would say that it's probably more of an informal policy, but it is something that they need to track in case this happens, in case the situation happens.
Also,
and it's good policy to do so.
And sort of follow on that, and also to follow up on Judge Long's question, can you address the ex post facto issue in the context of this is essentially second tier review? Can you address that from that perspective and the standard review that we would apply a second tier review versus, say, direct appeal?
Well, for the second tier review, you're not just looking at just a simple error. You're looking at whether there was an essential departure from the requirements of law that so if the court found specifically, the lower court specifically found that gain time was not awarded in this case and that ex post facto was not applicable. So if the court applied the correct law but just made a mistake, that would not be appropriate for cert review. That's not a departure from the essential requirements of law. But when you get to a point where there's a substantial miscarriage of justice, then maybe because the lower court made a specific finding that gain time was not awarded, ex post facto was not implicated. He wasn't awarded gain time because he wasn't entitled to it. So ex post facto was not implicated in due process. There was not a due process violation. Does that answer what you're asking me, or were you asking me something else? Okay.
Helpful, thank you.
And I think I wasn't keeping track, and I cannot see on the camera I'm using, but I think I'm just about out of time.
Yes, you are.
Okay, thank you, sir.
And thank you, counsel.
May it please the court. Let me address a couple of questions that were addressed in my opposing counsel's argument. First, Mr. McGill never got, this change in policy occurred before his sentence changed from life to 50 years. So we never got to see whether they would have been awarding incentive gain time to a 50-year sentence or not. But we do have examples cited in my petition that clearly show individuals in the exact same situation. Their offenses were committed within this window. Kenneth Purdy is the best example, who was released from DOC. And they later tried to rearrest him, claiming that they had improperly calculated his gain time. So there are individuals, and had Mr. McGill been in that situation before they changed the policy, he would have been in that exact same situation. I disagree with opposing counsel. If this court finds that Mr. McGill was receiving gain time, even if it was done improperly, it would be an ex post facto violation to take it away. And it would clearly be a departure from the essential requirements of the law.
But
Anytime.
do you disagree with her that Mr. McGill's tentative release date never changed, other than to reflect that he got a 50-year sentence as opposed to a life sentence?
It never changed simply because, again, they changed their policy before his sentence was reduced from life to 50. Had that policy change taken after he was resentenced, then the 50-year sentence would have reflected that gain time. And again, going back to this, DOC on page 115 of the appendix specifically told Mr. McGill that his gain time had been removed. So that was a change in policy. It wasn't that they were just doing this for record keeping purposes. They obviously were giving him these sheets every month, and they stopped doing it and then subsequently told him his gain time was removed. And they were doing it consistent with the exact way that I argued in my initial argument. They treated this as a level 10 and they gave him 20 days per month based on that. That is an award of gain time that he was entitled to, that he was expecting on a month-to-month basis for 20 years. And even if their change of policy now is consistent with what the legislature has intended, up until the change in policy, they cannot take away that gain time, and that would violate ex post facto principles to do so.
Counsel, just to bring this back before we close, bring us back to the fact that this is, I'm assuming you can see this as a cert review, a second tier review. In that context, can you think of another situation where a DCA on cert review rewrites a statute to basically give cert relief, where I guess the trial court was just interpreting the statute itself?
I can't respond to that particular question, Your Honor, but I can think of hundreds of scenarios where courts have granted cert petitions where there's been a clear violation of constitutional rights. And I can't imagine a more significant violation of your constitutional rights than being told that you're being given gain time for 20 years and then having them take it away because of their change in policy. That's the epitome of an ex post facto violation. Thank you.
Thank you.
Thank you, counsels, for your respective oral arguments this morning. This concludes our oral argument. We stand adjourned.